Yo, what's up, Houston? Jay Julio Vela here with Justin Harris with another wonderful edition of the Harris County Criminal Lawyers Association Reasonable Doubt. Justin, what's up, bro?
What's up? What's up, man? I put on a tie for you.
Oh, well, that's the least you can do.
I know. If I'm gonna do this for my dining room, I can at least put on a tie, right?
Well, first of all, I just looked at the screen and it's not a tie, Justin.
It is a tie. I
Yeah,
don't care what you or some of the judges in Montgomery County say. This is a tie.
you you tied it.
Yeah.
But that's called a bow tie.
Have you ever thought about how ridiculous a necktie is? Like, just stepped back and thought about how totally useless they are. They cost too much money. You drip food on them, and what do? Like,
No,
what is the point
look,
of it?
so number one,
Yours holds that microphone up.
It's true. It's true.
That's all. I mean, what is the point of a necktie?
Well, it's a formal thing. Look, fine. Now, I know Carson Yoakum's watching, and he wears bow ties.
He would
too.
agree. He would agree.
I doubt
If I'm gonna wear one, I don't want it to be in my way.
Yeah, but
I have to wear
nobody's
something around
saying
my neck.
that you're wearing a tie.
It's a tie. Just yours is called a necktie. Mine's called a bow tie.
Right. Hey, is that what you say?
Why are there two of me?
I know you don't say that in front of a jury.
No, I wear a necktie in front of a jury.
Oh, well, why do you do that, sir?
Sometimes I wear a bow tie. Depends on what I'm going for.
For the viewers at home, I'm looking this way because I'm talking to Justin, but I should probably talk this way. Justin, are you in trial this week?
No, this is like the first week I think I didn't have any trials set.
Well, I miss you.
No, but it's another week, so I know you're in like 3 trials, right?
Ah, it's funny. No, state moved for continuance today for a trial tomorrow, but next week it's heavy.
Yeah, you had how many juries have you picked at NRG? 11?
9.
12?
9.
9?
Mm-hmm.
Wow.
It's 9.
That's the record. For the record, that's the record. No other attorneys picked that many.
Yeah, well.
You're a warrior.
But, so it's also the record for most losses during COVID too.
It's probably also the record for the most wins for one single attorney.
Well, you got those who tried 1 and won 1, tried 2 and won 2. Todd, speaking of people who are winning, Todd DuPont got him not guilty, along with my hermano, brother, as we say in Spanish, or vice versa. They got not guilty on 2 counts.
Awesome.
In the 351st today.
That's great.
Who else
what were the charges?
One of them, I think, was an aggravated sexual assault of a child, and count 2 was an indecency. So they consolidated, and Todd DuPont and Jacob Vela walked him out.
The other JV.
On a not guilty. Yeah, JV Jr. True. JV Jr. Proper. Nah, Jacob.
That's awesome.
Jacob is his own man. He's waiting for his bar results. I think he'd do well.
Man, the state got taken down by Todd DuPont and a second chair, third 3L.
Look,
I like that.
No, the 2 things. The first thing is the state did a fabulous job. Such an incredible job. They killed it, and a lot of talent, a lot of room to grow if the upper brass would let them grow. Let them grow. I didn't let them grow, right? But 2, people are getting back in the saddle and starting to try some cases out there.
Look, we got El Presidente.
We got somebody coming on?
Joe Vinas is on. President
Joe,
of HCCLA.
where you at, bro?
Hey, I am currently at the civil courthouse at 201 Caroline.
It looks like
broken in. No, I'm at the house. I figured I'd pop in, see what's going on with you fools.
Please.
I saw you on another news source this week.
Yeah, what was that, Channel 11?
Yeah, what's going on?
So basically, with officer shooting earlier this week, there was, some people out there blaming the judge for not having his crystal ball out and predicting that this person 10 months later would shoot a police officer who was trying to execute an arrest warrant on him. And so, I'd seen it on a couple of news stations, specifically Channel 2 ran a story with HPOU president standing out in front of the courthouse, basically calling for the judge's job. And fortunately, Channel 11 wanted to get a little bit of a different perspective on it. So after they had him on, they called me, and I gave a quote and kind of gave some of the backstory as to what can properly be done, what kind of cases can get no bonded, what kind of cases can't get no bonded, and on those cases that can, what procedural steps have to be taken in order to for the judge to even be able to hold him at no bond. And so they ran the HPOU president, then they ran me briefly, and then Carmen Rowe, who's their legal analyst, kind of filled in the gaps. So yeah, it was a discussion on, the same discussion we've been hearing for the last year and a half about, judges letting people out on bond and.
Well, if we can, it's under chapter. What chapter are we on? The Texas Constitution or U.S. Constitution?
Well, if we can, before we get into like the legal breakdown of it, we're talking about the killing of senior officer police officer William Jeffrey, who I think was just a couple months away from retirement. And then Sergeant Michael Vance was shot and is in stable condition, but I think was in the hospital for a while by someone that was out on bond out of the 208th District Court, Dion Ledette.
Right.
And he was out on bond. If I understand, Judge Glass set reasonable bond amounts for him on 2 drug possession cases, but he had some really old aggravated crimes.
Right? He had a previous ag assault. He had a previous evading in a motor vehicle. And I think maybe now here's something that's interesting, because I looked at his criminal history before I went on there. He had a bunch of cases that the very same DA's office dismissed. So, the HPOU and whoever was out there talking about how he'd been arrested 18 times. Well, a good number of those cases were dismissed. And so that doesn't factor into a bond. I don't know. I guess before we go too deep into this, I saw Kim McTorry popped on.
So
hey guys, hey, how's it going?
So Kim McTorry was popping on as the show started. You're running for a bench, aren't you?
Yes, I'm actually running for the bench that you all are talking about, the 208 against Judge Greg Glass.
So,
so what?
Yeah, go for it.
No, you go for it, JB.
No, I was gonna say, Mr. President, why don't you take this one, huh?
Well. So I want to.
Sorry, my connection's breaking up.
Pick up where y'all were going, and not shine a light on Kim, but so Judge Glass was presented almost a year ago with this person in front of him. You were saying the Texas Constitution requires bail in certain cases.
So here's basically, there are several ways. And I guess when you think about the number of crimes listed in the Texas Penal Code and the other random sections where they have a, crime here or there, like practicing medicine without a license or, things like that are scattered throughout different codes in Texas. But when you think about all the crimes in Texas, there are only a few circumstances where someone can be held without bail. The only crime, just based on the crime itself, where someone can be held without bail is capital murder. And not even all capital murders. You have to, and that's, I believe, Article 1, Section 11 of the Texas Constitution. The state has to have a hearing where the proof is evident. We call it a proof evident hearing, where not only do they have to show that they're probably going to win at trial, but that they're going to get the death penalty. And so, forever judges were just holding people on capitals at no bond, and a lot of lawyers didn't really do anything to get bonds. It's a little more common these days and the state typically doesn't have that hearing. They would just choose to waive the hearing and allow the judge to grant a bond because they don't want to give us the proof evident hearing because it's just a strategic decision on their part. They don't want to have their case ready that early and then give us a free crack at their cops under oath and that kind of thing. So they forget it. We're not going to have this proof evident hearing. Judge, give them a bond. We're just asking you to make it, $1 billion or whatever. A second way that didn't come up in this case is under Article 1, Section 11B of the Texas Code of Criminal Procedure, the Texas Constitution, where if somebody goes out and violates bail conditions, okay, they commit a new crime while on bond, or they fail to appear, or they contact somebody they're not supposed to contact, the court can hold them at no bond after a hearing. There's no time limit on that hearing. The only way that this case could have been that I've seen, and all I've been able to do is look at the clerk's website just like everybody else, because that's all public record. The only thing I've seen that would make this defendant, and I'm intentionally not naming him by name, the only thing in this case where the judge could have held this defendant at no bond is because, what we call a habitual. So he had been to prison, I believe, on the evading arrest, got out on parole, or he was done with his parole, and then he got arrested, I believe, on the aggravated assault, went to prison, got out. Now he's a habitual offender. He's 25 to life. So because these were drug cases, still relatively small, I believe they were, second degree drug cases, 4 to 200 grams. But because he was 25 to life, the state could have asked the judge to hold him at no bond. Now, as you all know, but I'm talking to the audience, the only way that they can do that is to first file a motion to hold him at no bond and to request a hearing. They did that. But as we all know, since 2017 in Harris County, we have gone paperless. So motions, and that motion is now generated automatically, I believe, at intake. So no prosecutor really does anything in the trial court. They generate this motion as part of their intake packet, and it gets filed in the clerk's file. Now, what's not being told out there, and this, because this is not really the 10-second, soundbite that you're going to get.
That's sexy.
Right. Is there's a difference between filing and this is what I kept telling the reporter I was talking to with Channel 11, because she said, well, they presented. I said, no, there's a difference between filing and presenting. And so you file that motion, and as y'all know, it just kind of goes into the clerk's file and nobody looks at it. It is up to the movant, the person who has filed a motion, to present it to the court. Now, we're in November of 2020. We're deep into COVID. The courts are opening back up, but not totally. Everything's virtual at that time, or just about everything's virtual at that time. And you've got it's pre-vaccine COVID, so everybody's still pretty freaked out about COVID because nobody's got a vaccine yet. And you've got county officials, the commissioners, the judge, the county judge, and the sheriff looking, and a federal district court judge looking for ways to empty out that jail population if they can. So that's the climate we're under when this case gets presented to the judge. And there's no way, I mean, I guess there is a way, but I really doubt he just sua sponte on his own gave these bonds. I'm sure, because it is practice in Harris County, and I could be wrong. I wasn't there, and you can't tell by looking at the record, but I'm sure he did not just lower these bonds in an ex parte hearing. I'm sure the state was there. For whatever reason, that motion was not presented to the judge. It certainly was not ruled upon, because you can look at the motion and there's a blank order without a grant or a denial on it. Certainly, the record does not support that the state presented that motion and they had the necessary hearing within 7 days. So if on the 8th day, there's no hearing being held, whether or not there's a motion to hold at no bond, the judge has to give a bond. So it looks like in this situation, the way things went down, and I could be wrong, but it looks like in this situation, legally, the judge had to give a bond, had to.
So, Joe, you're in a courtroom right now. Presenting a motion that's been filed sounds difficult. Can you demonstrate what that looks like for our viewers?
Yeah, sure. You walk up to the judge, or if you're on Zoom, you unmute yourself and you turn your camera on. You say, "Judge, may I approach?" The judge will say, "Certainly." It's your turn. We're on your case. What's going on? I have a motion that is in your queue right now, and this motion is to hold this particular defendant at no bond. I need you to set us for a hearing within the next, 7 days. Can you do that? It is a very simple process.
There's got to be more to it, because the district attorney's office is throwing heat everywhere else but on themselves. So it's got to be more difficult than what you just did.
It absolutely is not. That is how you present the motion. That is all you have to do, is just bring it to the judge's attention. I mean, that's it. It's presenting something. Hang on, I'm getting a 911 call. I'll be right back.
Okay. Apparently Joe Vinas also is a 911 dispatcher.
Well, so who dropped the ball? Who dropped the ball?
Well, it seems pretty clear that if there's no hearing got set, that's not because Judge Glass would deny a hearing. That's because it sounds like what Joe's saying is that the state filed a motion and then just didn't do anything with it. I mean, that sounds like, if I write a letter, if I sit here and this letter I've been working on to you, JV, that I've written to you, and I put it in an envelope and I put a stamp on it, but I never walk it down to the mailbox and put the flag up, I don't get to go, "Hey, JV, did you get my letter? Why didn't you respond to the letter I wrote you?"
It's the thought that counts. Thank you.
I'm gonna pull a Kate Farrell. I'm gonna put glitter in it.
All right. Look, two things. First one is Greg. Look at that, Greg Glass. I will literally be surfing or on the lake or wherever I am, and I will see water crystal clear, and I'll be like, "Look at that, Greg Glass," because it reminds me of Greg Glass. The guy is one of the most honest, one of the most fair judges that I come across. Anything that I talk to him and come in earnest, and he sees that, he is one of the most just judges that I've been around.
Is there anyone more senior than him on the bench in the district courts right now?
Yeah, there's a couple, because this is only his first term. So there's a couple, Judge Harmon, Judge Hazel Jones, because she had 4 years between 8 and 12.
Fault. Judge Collins was on the bench before Judge Glass. That's
right. Yeah, this is just his first term. So
where's your bailiff, Joe? There's somebody lurking behind you in your courtturm. Where's a bailiff?
Yeah, that's my
the clerk.
Yeah.
Oh,
there he is.
Hey, buddy.
Hey, man. Okay, but two is, number one, your dad's one of the best lawyers in town. Did you know that?
He doesn't believe that. He doesn't believe that at all.
He is. Your father is he is the best. He is one of the best lawyers I've ever known. But two, with Judge Glass. Okay, so is it the prosecutor's fault who didn't push it to the queue and get the order signed? So is this blood on the hands of Kim Ogg?
I mean, and that was, it's a situation where people are looking for, who are we going to blame? And to me, the person to blame is the defendant. I mean, that's it.
The person who did it.
Right. And that is where the blame stops. And it's, you can't really, people aren't going to get, I guess, satisfaction out of blaming him because he's already dead. And so they want to find somebody who they can go out and take their anger out on. And I get people are angry, and they should be. I mean, this is not something, I don't think anybody here is standing up for this guy. He's, what he did was terrible. It was wrong. It was tragic. This 31-year vet with HPD who, like Justin said, was just months away from retirement. I believe they were building, a retirement home. He's a father, husband, sound by all accounts, a great guy. It shouldn't have happened. And so it's terrible, and we all should be angered by it. But that doesn't mean that, as Justin pointed out earlier, Judge Glass gave this guy a bond 10 months ago. And you're asking these guys to predict the future. And now the backlash, the pushback on that is, well, let's just take the option away from them and keep everybody in jail. But that's not going to work. The jails are already overcrowded as is. So where are we going to put these people who are presumed to be innocent in jail? They might have a violent history, but in jail on a non-violent offense. I mean, there's no doubt this is a violent dude, but to keep somebody who's currently charged with a non-violent offense in jail means you only have a finite amount of space in the jail. Back then, it was overcrowded. I think there were between 8,000 and 9,000 people in the jail.
It's been close to 11,000 right before COVID.
Right.
People don't realize, like, that's 11,000 people spread between 3 buildings. And it's really more like 2.25 building. Like
Little Baker is little.
Very much.
Yeah.
But that's a lot of people. I mean, I was reading the article about the lawsuit that the jail employees have filed, that they wanted to hire 500 more. And then I was like, that's a ton of people. And I saw that they have 2,500 employees who work in there.
Yeah.
Like, those are just buildings with thousands and thousands of people living there and coming and going every single day. Mm-hmm. And when you got a pandemic going on, and then you have the Constitution. That's the overarching thing. The Constitution says that you're entitled to bail, reasonable bail, to secure your presence in court and protect the community. And there's no way to know that someone who's picked up on 2 drug charges is going to 10 months later, when a warrant's being executed, shoot 2 police officers. And this is my opinion. It's awful for HPOU, any other politicians or anybody who's making this something about the judge having any so-called blood on his hands. They're politicizing the death of senior officer Jeffries and the shooting of the other officer. That's who's politicizing it. And
I've
correct
heard,
me if I'm wrong, but go ahead.
No, I've heard 2 things. The first one is that they have precogs in the Harris County District Attorney's Office.
They have what?
No, they have precogs.
Yeah, 3 of them in a nice warm bath somewhere in the basement. Yeah.
Oh,
I heard it was Joanne Music, Sean Tier, and David Mitchum. And they're like sitting all there like.
Yeah. Well, I mean,
look, the second thing is, speaking of overcrowding and population, yes, the Harris County jail employees have filed a federal lawsuit over working conditions. Judge Lena Hidalgo says it's very political at this moment. And they say that the jail needs 500 more humans, 500, to adequately serve the jail population. And what they're saying is that this is what the Harris County Deputies Organization President David Cuevas says. There are so many knives and shanks that have been discovered. It's incredible that there's not more prisoners that have died or more employees that have not been stabbed. He says due to the shortage, jailers are not even allowed to go to bathroom breaks. And the issues extend to outside the jails as well, he says. They're now recruiting our patrol deputies to help supplement our jails, Cuevas said, and that's creating a further violent risk in our community. So you have COVID in the jails. You have this, they need 500 more humans to monitor the jails because they're finding so many shanks. It's like a boiling pot, a melting pot like we've never seen. I just find that incredible.
I do too. And I also don't understand the few cases I've worked on with contraband in jails where like Texas Rangers are involved and the feds get involved. It's pretty clear the contraband's coming in from people who work in the jail. I don't know how you get a knife into the jail. Well,
there's shanks, they
make them.
shanks. Yeah.
Okay, out of what? Because everything's either cemented to the ground or made of like flimsy plastic, right?
I've heard of hooch being made in the jail.
Yeah.
Yeah,
Hooch,
I can see that. You just need
shanks.
sugar, water, and like, a dark spot. But making something sharp that you can use to actually hurt somebody, I don't know. I'm not saying it's not true. I'm with you, JV. 500 more people. I don't know how that's going to fix the problem. When I first saw the headline, at least, I kind of was like, if the employees are saying that they're awful conditions in there, what must it be like for the inmates? But I don't know.
Lena Hidalgo responds with, what we've done is we've created a new court, a new felony court, she said. We've brought on visiting judges and we've brought in associate judges, about 10 plus in total. Some of them have started, some of them are starting here in the next week or so, and we've invested in funds for law enforcement to be able to process body camera footage. Hidalgo called the lawsuit itself political and said the timing coincides with her re-election campaign. I mean, is it Hidalgo's responsibility to work out those jails? I mean, who ultimately does it fall on? Kim Ogg, District Attorney Ogg, the judges, the defense attorneys?
Well, Ed Gonzalez is in charge of the jail. He's the sheriff of Harris County. He's also named in the lawsuit. Lena Hidalgo, Ed Gonzalez, and all 5 county commissioners are named in the lawsuit. The other thing I was going to say about the situation with Judge Glass and the Houston Police Officers Union and the shooting of and killing of the police officer, there's also, we're in the second or third special session that the governor's called, and hasn't he just added an agenda item that involves so-called bail reform that really doesn't reform anything? It's more like gut the Constitution reform.
Right. And so the thing is that in order to change, no bail reform legislation can change the case that we are talking about short of a constitutional amendment. And so that's what they're going to have to do, is put it on the ballot for the people to vote on. And I don't know what the population percentage has to be in order to vote it. I don't know if it's like a federal amendment where you have to have 3/4 or what, but it's, that's a little tougher. But as we all know, after seeing the way that things get put on the ballot and the way they're worded, because the people who write them get to phrase them. And so I'm sure that whoever authors this bill or carries it, and we've got our suspicions as to who that's going to be, is going to word it such that it is going to make it like it's the only choice and that we're all going to die if it doesn't pass. Right.
I think I heard on the radio it was Joan Huffman is sponsoring it.
Wasn't she a judge? I wasn't a lawyer when she was a judge. Or wasn't there a Huffman as a judge, or no?
Yeah, so she was a judge here in town for a while, probably a decade. I was actually, my first trip up in felony, I was the 3 in her court. Apparently he wants to be on TV.
Come on, dude.
The floating head.
This is a TV show.
Floating head.
Yeah.
Do you want to be on TV?
Mm.
You're
there. My part-time.
Okay, go on, get
it. You can do a TikTok, real quick TikTok.
Mr. Jones.
Yeah, okay, we're talking.
Mr. Joe, actually.
Yeah. All right, hit the road, dude. I'll be out there in a minute. Yeah, so she was a district court judge for a while. She started at the DA's office the same way I did. She was a secretary in the intake division before law school, went to law school, came back, was a prosecutor, went up to district court chief, and then went to the bench, and then retired in 2006, I think, 2005, somewhere right after I had left her court, and then went straight into the state Senate.
All I've ever heard are bad stories of her, man.
Yeah, I mean, look, I was in there for 6 months. And you know, I'm not going to lie about it. It was a very state friendly court. But it wasn't a, you know, we didn't get everything we wanted. We got most everything we wanted, but we didn't get everything we wanted. You know, my first PSI I had in there, you know, and I'm a rookie 3. My chief told me it was a 1st degree drug case. My chief told me to ask for 5 years. And then, you know, when she was getting ready to pronounce her sentence, he said, watch this, she's going to surprise you. And she gave him deferred. And I'm thinking that's what he should get. I don't know why he told me to ask for 5 years. But I was like, and so she gave the very first contested matter I had in there. She gave the guy 5. My first jury trial in there was a less than a gram, really weird case that I ended up winning. But they went to her for punishment, which was almost per se ineffective assistance. But she gave that guy probation.
This is what I'm saying. It always comes that's almost, yeah, this is what I'm talking about.
Yeah. I mean, it was, look, she's nice. I get along with her. There's a particular former president who's probably going to call into the show right now.
Yeah, I'm like, where is he?
Me.
Where is he? Doesn't he have the link?
Is his name Bob Rickman?
It
rhymes with that. It rhymes with that.
And so, yeah, I mean, I'm sure he's going to call her. He's probably going to send me death threats or something.
He may not be able to because his head may have just exploded.
No, I mean, you know, she was always very pleasant to me. I didn't see her really. I never saw her berate any defense lawyers or be disrespectful to defendants when they were in her court. She did kick one lawyer out of the courtroom, but she kind of deserved it. She rolled her eyes at her. And I don't want to name that lawyer by name because y'all know her. But this was back when she was just a brand new lawyer and she was working for another lawyer who's since been disbarred. And they were trying a case and Brad Hart was trying it. I was sitting second with Brad. And so she just out of nowhere, I don't think the jury was in the room. I think we were arguing outside the presence of the jury, and she just pointed at her and said, get out of my courtroom right now. And Brad and I are looking at each other like, what happened? And so the lead counsel, before even asking, just pointed at her and said, just get out. And she did. And then he asked what happened. She said, well, as I was talking, I think maybe we were doing the charge conference or something. As I was talking, she was looking at me and rolling her eyes at me, and I saw her do it more than once. So that's it. She's not coming back in. And so we had taken a break and he comes back and he's like, look, Judge, she just wants to come in and apologize. She said, nope, not happening. Done. She's not coming back in here. Wow. That was about I guess maybe that's a bad story, but the lawyer deserved it. You can't roll your eyes at a district court judge or any judge for that matter. And so that was about.
Can't do it to a JP.
I had this one guy who winked at Judge. Remember at Judge Court 9, Analia Wilkerson?
Oh yeah.
So the guy's accused of this assault, and he's sitting there winking at the judge, like, "What's up, mama? Like, what's up, babe?" No. And I'm just sitting there like, "Dude, you can't wink to the judge, bro." Anyways, this is after we've already elected Judge Punishment. And she lit him up, man. She lit him up. You can't do that.
Did she wink at him as he went back into the holdover?
No, I was like, dude. And then he filed a grievance against me. And whatever. Yeah.
Yes, that's always the way.
There's that story. Hey, speaking of trying to manage the backlog, what's up with Managed Assigned Counsel?
I don't know. I mean, I don't know. There was a Zoom yesterday that I had another meeting that I was attending at the time, so I missed it. But I don't know. I mean, I'll probably meet with those guys next week at some point, just to kind of get some better details. But you know, who knows? I don't know.
Do you really think we have any influence on what they're going to do?
Maybe. I mean, I think they're going to do what they're going to do anyway. I don't know Ken Harden at all. I know about him. I know people who know him. I hear good things about him. I hear he's a really nice guy. Other than that, I don't have any experience with him. I know Nick Hughes really well.
Right.
I trust Nick. Nick is, usually the smartest guy in the room. And I'm glad Nick is where he is. And I told him that when he appeared.
Good move by Kenneth.
Absolutely. I mean, that's a strong move. That right there shows he's at least got good judgment, because he went out and hired a guy who is pretty well known and well trusted among the defense bar. So solid hire on his part. And I'm glad Nick is where he is, because Nick knows what he's doing. And so I feel comfortable with that. It's just, I don't yet know kind of where I sit on that issue, because I don't know enough of what they're going to do. They've got plans in place and direction, but how they're going to get there, or what specifically they're going to do, procedurally for these plans, is still, a mystery, at least to me. I mean, it may not be to them, but, I know, Justin, you were in the meeting yesterday. I know there were a couple other board members there. I've heard different things, mixed reviews about what was said or what wasn't said. And so
do we know when?
Well, there's two things that are pretty clear from it. I agree that, any kind of new department, anything new, you don't know what it's going to look like and how it's going to work until it's actually rolling and going along. So that, I think the jury's going to remain out until it's in full effect, and it's only operating in 2 courts right now. And I'm not even really sure how it's kind of operating. So I thought if it's operating the way it's supposed to, like, everybody on the misdemeanor list would be getting calls for court 9 and court 12 on like a rotating basis, but I still don't know how that works. But there's 2 things that are not in dispute. Well, 3 that are not in dispute. One is it's happening, but the second thing is that they are seem to be trying really hard to at least appear transparent and open. Every single month, they are having these open meetings on Zoom that you just register for, and you get the link, and then you go in, and it's all the top people, or maybe it's like all of them right now. I don't know, because they're still growing, and they just are literally like, here's a few new things, and then what questions do you have for us? And yesterday's, I got in there kind of late. Fortunately, I got in there right as somebody else who got in there late asked for a recap of everything. Kenneth gave a recap of everything, all the other questions that have been asked and topics that have been covered. And then he just said, any more questions? And it went past the normal hour. Then they're just literally like, okay, we'll just sit here in case anybody has any more questions. And they answer all the questions. So, and then the second thing is that the third, where we are on the count. The next thing is they seem to be genuine and sincere in what they say. So if nothing else, we can get them on the proverbial record about how things should work, how things will work, what they will do, what they won't do. And if they change that later on and they go back on what they've said, and we should be able to nail them to the wall on that.
What were some of the questions that you heard?
Before I got on there, apparently there was a big discussion about the immigration attorney or attorneys that they're going to have on staff, and how that's going to work for being able to get, they have them on staff. What I understand right now, they've got an immigration attorney who's there, like by a bat phone, ready to give consultations to criminal defendants regarding the immigration consequences of a plea or a trial or a conviction. And I asked questions about whether there's anything to speculation that I've heard that they're going to require us to, reveal our case counts out of Harris County. Not that it's a secret or anything. And Nick did a good job of kind of pointing out, like, if you're listed attorney of record on a case, that's public information. But they did say that there are no plans at this time. They don't even have the ability to sit there and start asking attorneys to report the number of retained cases they have, the other counties that they do work in, or anything like that. And he did say that if that time comes, it's only going to be in an effort to make sure that they are matching what's required of them through the funding that they receive through grants and through TIDC, because they have to report that information back. And that makes sense. I mean, I already have to report, all of us do, every year to TIDC and via the state bar mandates or Supreme Court mandates, percentage of my practice that's appointment work, percentage of my practice that's retained work. And so they at least seem transparent and open. I took that minute to Kenneth brought up reasonable doubt and HCCLA by name during the meeting. And I said, well, since you brought it up, when are you going to come back on the show and talk to us some more? And he said he was definitely going to do that. He said now that he's got people working for him, because last time he was on, it was like the week or the day that he had gotten announced as the director. So he said he's willing to come back on. He may bring some of his staff with him, and we can, all ask questions and maybe get questions beforehand that we can ask them, voice our concerns. But I will say, and I'll say it to him, that I believe that me and my office provide very good and effective representation for people who are indigent and can't afford my services or the services of any other attorney. And if it becomes too arduous for me, or I believe that it starts to become too private and personal, basically, into my business affairs, I'll step away and they'll lose me as an attorney on that list. I don't have to play that game. There are 254 counties in the state of Texas, and I have a card. So, and I think that if enough attorneys did that, then it might make them change. So I think, JD, when you ask if we have an influence, I think that maybe the better question is how much influence do we have? But I do think that we have some influence because they are at least willing to talk and listen. And I don't think that they're our enemy at this point. We'll have to see, like Joe very validly points out, how things actually get implemented and what the process is. But I'm going to stop talking.
Do we know when the other, currently there's 2 courts that are doing it. Do we know when the rest of the misdemeanor courts will be adopting the MAC or have already adopted but will implement the MAC? And do we know a timeline for felonies?
Felonies, I think they say they want to start next summer. I don't know if unless they do that right unless it gets funded immediately. I don't think TIDC has they might have their summer meeting in June, and I don't think the funding comes through till September or maybe October. I don't know. I don't know what their fiscal year is, but I hear that they want to start in the summer of next year in felony. Going back to what Justin said about case counts, I had heard that there was this rumor. I've never heard the rumor. I heard today that there was a rumor that they were going to require appointed lawyers to reveal their case counts. I'd never heard that before, but it's pretty clear that by whatever means they are going to count every case they can, whether it be a Harris County appointed case, a Harris County retained case. They can sort of get those. They'll go get whatever other counties they have the means to get. I don't know if they're going to try to get federal cases, but they're not asking lawyers to reveal their case count. They're going to create their own case count. And by whatever means they can, they'll get it. And Nick has said that on a few occasions. So that to me is one thing. I've never.
Is there a concern there?
Well, and that's what I was just getting ready to say. It's case counts to me. I get them in theory, but if you look at and case counts is something that I could talk for hours on, and I don't want to do that now. To me it can be concerning. because right now, kind of Justin, like you were saying, we've got an obligation to the bar. We certainly have obligation to our clients, but when I left the DA's office, and here in Harris County, a great number of lawyers, especially those who do appointments in felony, were prosecutors for a long time. Most of us didn't leave because we got fired. I mean, there were some political hatchet jobs done at the various changes of administration over the last few decades. But most of us left, kind of a quality of life. I don't want to put up with bureaucracy anymore. I'm not, I don't have enough freedom for myself or my family. So I'm going to go start my own practice. And so that's why most of us left the DA's office, not because we didn't want to be prosecutors or hated the job. It was just all the red tape that came along with it. And that's kind of the trade-off. You're in an office, especially a government-run office, and you give up certain things. A lot of times you give up pay, you give up flexibility, you give up time with your family, but you get in return for that, you get retirement benefits, you get health benefits, you get no overhead, you get your staff supplied for you, and you get paid every 2 weeks, regardless. So that's the give and take. And that goes for prosecutors, that goes for the PD's office, that goes for anybody else who works in a county, office. And there are, 50 different divisions in the Harris County government or something like that. We as private lawyers, the three of us, we get that freedom. We can take vacation whenever we want, but we don't get paid vacation. If we don't work, we don't get paid. And so we have a lot more freedom. Hopefully we get more money. That's not always the case. Sometimes it is, sometimes it's not. But we don't get paid every 2 weeks. We get paid whenever we get paid. Sometimes we don't get paid. Sometimes we end up working for free, but that's the trade-off. Part of the issue that I've seen with the MAC coming in is, in addition to taking court appointments at a rate that is lower than really any of us would charge on a retained case, in addition to answering to the, filling out a voucher, at the rate of every 6 minutes, and billing the county, which they have the right to do that. And I'm not complaining about it, but that's a bureaucratic, ministerial thing that we have to do. Now, not only are we responsible to our clients and to the court, but now we're going to be responsible to another lawyer. And at least in my case, another lawyer who hadn't been licensed as long as I have. You look at these senior guys on our board, Danny Easterling, or guys like Bob Loper and Wayne Hill, God help somebody from the MAC office if they try to call those guys up and question them, because that ain't going to go well for them. So that's another issue that I see. But the main issue that I have with the MAC, a question that needs to be answered now, I think, because they've been around for a year, is, there's discussion, and I don't know if it's a rumor or not, but there is certainly major discussion that in order to, on an appointed case, in order to get an investigator or an expert witness, you've got to go to the MAC. Now, to me, as far as the Constitution goes, there is no such thing as the MAC. It doesn't exist. There is a relationship, obviously, between the attorney and the client. I mean, the Sixth Amendment is clear about that. And the case law from the Supreme Court drags the judge into that. You look at all the cases where, Akey or, Akey versus Oklahoma or Hinton versus Alabama are a couple of Supreme Court cases that come to the top of my head that bring the court into it. And if we as a lawyer representing an indigent client, whether they're retained or whether they're appointed, we as lawyers have the Sixth Amendment duty, and they have the Sixth Amendment right to have an investigator and to have an expert. And if you look at Hinton versus Alabama, it's got to be the right expert. And so this other lawyer who's not, or this other law office does not represent the defendant, to me, has no place in the Constitution deciding who works with the lawyer on that case. Period. End of discussion. That's just my opinion. Maybe I'm right. Maybe I'm wrong.
That's the law. That's the law.
Well, I think that you're right. And I think that what has to happen is we need to just continue doing things as we are, going to the judge, filing a motion, getting the judge to grant it, and in that motion and that order, specify the investigator that we're going to use. Put it under seal, make sure it actually gets sealed, and then double check that it actually gets sealed.
Right.
But because at the end of the day, the MAC doesn't exist, but the judge, under the Constitution, the judge does, the defense attorney does, the prosecutor does, and it all surrounds the defendant. And if we couch this in terms of constitutional obligations to our clients and constitutional duties that our clients are afforded, I think that the judges will grant that. And I think that the judges that we have right now, even the ones that have been the most supportive and involved in forming the MAC, I think they will listen. And I think that I don't think they're going to ignore any concerns that we have and deny us our own investigators, but we've got to do it. We have to go through file the motions. And then do that demonstration you did earlier, Judge Joe, of presenting the motion to the judge and getting a signed order, and then including that time on the voucher. Well,
and here's a and I agree, and that is exactly how I'm going to continue to practice on my cases once the MAC is implemented. Is I'm going to go to the judge. I'm on an AICI motion, either on an investigator or on an expert. I'm going to go directly to the court and say, this is who I need. This is why I need them. And I'll demonstrate ex parte in camera if I need to, my client's need and their indigency. The problem that I've run across when I've talked to different judges, because I've talked to several judges about this, is the issue with the MAC is, and part of my problem is I've kind of, and I don't mean to politicize this, but this is just the best example I can think of. If you go back to 2009 with Obamacare and the famous Nancy Pelosi quote of, well, we got to pass the bill in order for you to see what's in the bill. I don't buy that. And I know in the real world, sometimes that has to be done. But in talking to these judges about how this is going to happen, and I've been talking to them for a couple of years on it, is what I have heard from them is the way it's structured, and nobody can answer for me why it is structured this way. But the way it's structured is that once the vote happens and the MAC is enabled and created, all the authority that they give to the MAC, they give to the MAC, and they don't get any say in it. And so and what's crazy is they can come up with the plan, and the day after the MAC gets the plan and gets authorized, he can completely scrap it and do his own plan. And to me, that's a little scary. And it's got nothing to do with Mr. Harden or Nick. Because I don't think you set up an office,
that kind of power.
Right? And you don't give somebody you like that kind of power, because he's not going to be around forever, and the next guy who follows him in could be.
You may not like.
I have heard that Harden's a take it or leave it kind of guy.
I mean, I don't know.
That's what I've heard. That's what they're saying.
But anyway, so some of these judges have told me, they're like, look, if that's the situation that it's under, and the MAC denies you, well, that's it. And my response has been no. And I've told these judges, so I'm not talking behind their back. The ones I've talked to, I've said, look, this is the way I'm going to do it. I'm not going to go to the MAC. I'm going to come to you, and I'm going to present this motion, and it's going to be filed, and it's going to be on the record. And I'm going to push you to give me a ruling. You're either going to grant it, which means I get what I want and I win. Not that this is necessarily a fight, but I get my way, and I get to represent my client the way he or she needs to be represented, or you deny me, and that's automatic reversible error, and my guy wins. So
I think they're going to say go to the MAC, and I'll agree to have to go to the MAC. I don't trust. I mean, I trust some of them like that. I do not trust all of them like that.
Right.
No, I don't trust all of them like that either. And we saw this in real life, in I think a county a little to the south and the west of us, where they were requiring private appointed attorneys to use the public defender's investigators.
Right.
And from what I heard from people who worked in the public defender's office, who I trust very much, they didn't even want to use their own investigators. They were a couple of, I don't know them personally. I'm just repeating what's been told to me, but jaded, cynical, near retirement police officers who just went and took this job so they didn't have to worry about getting shot at as much. And I'm going to have I have a strategy behind which of the investigators that I have at my fingertips, which ones I use. It's based on what I need, what kind of case it is, the
what part of town it is.
Yeah.
Not. Yeah, exactly.
Yeah.
I know their approaches. I've sat down and just had lunch with them just to get to know them a little bit better. So I'm just not blindly sending one out. But I don't know if either one of y'all have ever experienced this, but I can be a little abrasive sometimes. Sometimes I turn off people, and I worried, like, what if I get sideways with the investigator that I'm forced to use in the Max office? They're not going to hurt me.
No.
They may hurt my client, but they can hurt my client's case, and I may not even know that. Yeah. So, I think that these are all valid concerns. I do think that they need to answer these questions, and like you said, Joe, like now. Yeah. So I do hope that if Mr. Harden, Director Harden, is watching, that he pulls out his calendar, finds a Thursday around 8:00 when he can come on, and that's at least one thing that we can talk about, and that we can take away from that conversation something that we can like really sink our teeth in, and it's more than just words, that he can point to where we can have that assurance, because I micromanage everything. JD was giving me crap about my bow ties, and I didn't say the real reason why I wear bow ties, but there's actually a reason behind it. Everything I do, I have a reason behind it. It's theater in some places, it's strategy in every other place.
Hey,
and
look, I'm getting the buzz to start the rap. El Presidente, thank you. We have Joe Vinas, right? The president of Harris County Criminal Lawyers Association, on the show. Send us out, Joe.
I appreciate it.
Well, I'm doing this. They're giving us a star rap. Why don't you send the public out? We end on you.
All right. Well, thanks everybody for watching. The two-headed monster tonight. JB, Justin, as always, y'all do a great job. John, thank you for being back there in the back. Katie, I don't know if you're back there with him, but
and Mark's in the booth.
I appreciate it. Everybody have a good evening. See y'all next Thursday.
And
thank you.
later.
Yeah.